Hi, everyone, and welcome to the Video Legal Podcast, Legal Questions and Answers in Layman's Language. And today our topic is medical malpractice defense. Very interesting. A lot of our podcasts focus on the plaintiffs, which are the people that are bringing the action. And tonight we're going to talk about the defense. Tonight's a very interesting topic, as I mentioned. And we have a person who has worked in one law firm for over 40 years and is one of the most prominent defense attorneys in the medical malpractice field. The firm is Martin, Clearwater, and Bell, and I'm so delighted to introduce Sean Dugan. Sean, we're very happy that you're with us.
Pleasure to be here, John. Thanks for having me.
So we're talking about defense and we're talking about malpractice. Let's begin by just giving your perspective, which is decades of experience in terms of what do you bring from a defense perspective to the medical malpractice field.
What we look for when a summons and complaint is served by the plaintiff alleging that a doctor or hospital did something wrong that caused them injury, we look for several things. What are the facts that they claim underlie the allegation? Number one. Number two, where is this action being brought? Is it here in the Bronx? Is it in Staten Island? Is it a proper, what we call, venue, place of trial? Number three, we look at what is this aggrieved person claiming? There could be a claim for medical malpractice or negligence, for lack of informed consent. What type of damages are claimed, John? Economic loss, pain and suffering, maybe derivative claims for a loved one who's sustained an injury or passed. We try to get a feel for the case. What does the plaintiff, the person bringing the case, think? When we sort of get our hands around that, we'll call our client. What does our client think? Whether it's a hospital, a physician, a nurse, a physician's assistant, whoever our client happens to be, do they agree with any of the allegations? Do they disagree? Just to get an initial feeling for what's what. That's before we have anything other than a summons and complaint.
Who basically in the malpractice field are you representing as a defendant? Who is your class, so to speak, of defendants?
Medical practitioners of any sort, nurses, physicians, whether they be surgeons or internists or ophthalmologists, dentists, any medical professional, and hospitals. We have many hospital clients, and we also represent many clinics, John, medical clinics.
You mentioned an interesting thing, I think, and that is that if an allegation is brought, you go to whomever the defendants may be, and there may be some situations where the defendants essentially support the allegation that was made. If they're not supporting it, they at least are aware of the fact that there may be validity to the allegation. Does that happen much?
It happens. We have represented hospitals where when they get a summons and complaint, they do their own investigation and will say, what do we do now? Well, what we do now is call the plaintiff's lawyer, the person representing the person bringing the lawsuit, and start a conversation about what are we going to do to resolve this.
When you start talking about making contact with the plaintiff, the person bringing the action that is claiming they were injured, what are the kinds of questions that you would ask or seek to ask from a potential plaintiff?
I'd like to know what the lawyer now, as opposed to the document, the summons and complaint they served, what does the lawyer think about her case? What are you really claiming? There's always a lot of excess verbiage pleaded to cover all bases, which we totally understand. But lawyer to lawyer, what do you have here? And we listen carefully then we go back to in this case, a hospital we're talking about, and ask for the patient's hospital chart. Does the patient's chart match in any way what the lawyer is telling us she thinks about her case? So it's a process. It's not one conversation, the case goes away.
When you talk about potential injuries in a malpractice, what are the kinds of injuries? What bodily parts do you see a repetition of for the kind of claims that we're talking?
Oh, we have a medium-sized firm, so the lawyers tend to specialize a little bit. We'll try any case, but for instance, I would do neurologically impaired baby cases, neurosurgical cases. I have a partner who would do ophthalmologic cases. Anything that can go wrong will go wrong with any part of the body.
Are there any particular parts that strike you over the years? 40 years of doing these cases, any sense as to which parts of the body tend to be made claims under malpractice?
I don't think so. I mean, the standard, most usual claims are probably orthopedic claims, neurologic claims, whether it be in the brain or the spine. Obstetrical claims are probably the most expensive. Pediatrics, not so much, but you know, they'll pop up every now and then. I don't think of anything that you see tons more than other cases.
Let's go to an area that you have probably hundreds and hundreds of cases that you have been on trial over the years on. And let's talk a little bit about that, what your experience is, because I think the average potential client of a malpractice case looks at a trial and either gets very worried about a trial or is interested in knowing that that is the end game in many ways. So why don't you talk about your experience as a trial lawyer?
So from our perspective, from my perspective as a defense lawyer, I've never tried a case for a plaintiff. It's always the defense. I would say what I look for is truth. If somebody on either side is making stuff up, it's going to go bad for that person on whichever side it might be. Stick with what you know the facts to be, number one. If you don't know something, instead of making it up, just say, I really don't know that, which is fine. Number two, I would say, don't exaggerate. Again, one way or the other for the plaintiff or the defendant. If you have a wart, I have a wart, let's talk about it. Don't lie and say, I don't have a wart here. That funny thing on my hand isn't a wart when it really is. And if it causes a certain amount of discomfort, define that. I would not tend to exaggerate because you're going to be caught on exaggerations, probably, on either side.
How many would you say cases, let's say, for example, 50 cases are submitted to you and you may be working on or have worked on. In the overall picture, how many wind up going to trial?
4.
So that's 10%.
The vast majority of cases are discontinued when one side or the other figures out, I don't have what I thought I had. Why did I ever bring this suit? Or why did I ever defend it? Why didn't we settle this a year ago? That's pretty much.
Is it a challenge for you on the defense side if a case is progressing and it may at some point look like it may be headed for a trial? Do you want to do a trial by and large, or would you prefer to settle the case?
Oh, personally and professionally, I love trial work. Explaining things to people so they can understand the intricacies involved in plain English language, not fancy medical terms, is what I love doing.
What do you think are give me a couple of the primary focuses of your attention as a very prominent defense attorney? What are you looking to do in terms of the conveyance to the jury? Because at the end of the day, they're going to make the decision.
Most cases are not decided on the plaintiff's testimony, because what does the plaintiff know about the medicine involved? It boils down to essentially, on most of the cases, not all the cases, what we call a battle of the experts. What do I mean by that? Well, there's a funny level of proof a plaintiff has to achieve in a medical malpractice case. In an automobile case, in a trip and fall case, the standard is what an ordinary reasonable person would do or not do. In a medical case, that is not the standard. The standard is, did you depart from the standards of care, medical care? And who sets the standards of medical care? Doctors. So you need an expert as a plaintiff who will look at the file, read the transcripts of the plaintiff's testimony, the defendant's testimony, look at the hospital and medical records, and will support your contention that the doctor, what they say, departed from the standard of care and committed malpractice, A, and B, that specific departure caused injury, and then how damaged is the plaintiff. So it turns out you get your experts as a plaintiff that are going to say there were departures from the standard of care. The defense has his or her experts who say, I disagree, this was perfectly appropriate, maybe there's more than one correct way to treat a disease. Maybe your expert's going to say there should have been surgery. My expert may say it was perfectly appropriate to treat this condition medically without surgery. And if they're both correct, there's no malpractice because the standard of care has been met.
When you make a presentation to a jury, you will, let's call it, it's the opening statement, the initial statement that you make to the jury, and then you've got your closing statement at the end when you're summarizing your defense position.
Right.
Let's talk about that, and I'd be interested in hearing your perspectives on each.
So the opening statement, when you think about it this way, there are 6 people who are going to be your main jurors and 2 or 3 alternates in case one of the 6 gets ill or can't otherwise come to make a decision. They don't know anything about, let's say, a neurologically impaired child's brain. How does the brain work? Well, why would 6 people picked from our venue here in the Bronx know anything about how the brain works? They have to be educated by experts. They have to be educated by experts who speak their language so they can understand before they make a decision. So in my opening, I like to educate the jurors as to what I honestly believe they're going to hear. Now, I may talk a little bit about what you, as the plaintiff's lawyer, what I expect you to say. You can't get into that too deeply because the opening is about what I intend to prove. But in setting the stage for the jurors to understand how this disjointed testimony is going to come in, it's not like a book where you start on page 1 and end on page 150. First comes, let's say, an expert. Then will come some fact witness. Then at the end might come a plaintiff in the sequence of events at a trial, and it's sort of confusing. So the opening to me is explaining to the jurors in a coherent fashion what I believe they're going to hear that's worthy of belief. Not everything that's said in the courtroom is worthy of belief, and whether it's your side or my side, you might as well point it out early.
What about your closing?
The summation is a trial lawyer's forte. You can really make all inferences that are anywhere near reasonable from any evidence and tell your story. And what's your story? On the plaintiff side, I'm sure you've already heard, the story is how careless somebody was in departing from the standard of care and causing significant injury. On the defense side, it might very well be, John, we agree that this person, this plaintiff, has sustained a substantial injury. That's not an issue. What are the issues here, folks? Was the doctor reasonable? Did he comport herself with the standard of care? Now we have to look at the experts. What did the plaintiff's expert concede in that regard on cross-examination? Did he recognize any textbooks which contain information contrary to what that expert was telling the jury? How about medical journals? Did he acknowledge any medical journal articles on that particular issue which dispute the position he took? And my favorite one, how about common sense? Does it make sense? Does it hold water? Or is it really reaching?
Do you think, on balance, again, going back over the hundreds of cases that you've tried, do you have a sense that the jury at the end of the day gets the relevant facts to be able to make the judgment? Are you satisfied with decisions by and large from the plaintiff, from the jury over the years?
Without exception.
Meaning?
I think the jury system, when properly educated and when the judge lets you do what you have to do to explain it to the jury, they come to the right decision. I may not agree with that decision deep down in myself. Really? You're giving money for what? But I can understand in every case how that happened. We had one case, terrible pediatric cancer case. The doctor did absolutely nothing wrong. The jurors heard the whole case. They came up with a modest verdict against the hospital, not against the doctor, which made no sense whatsoever. So we asked the jurors afterwards, what happened in there? Because there was a lot of loud voices and yelling in the jury room over 2 days. What happened was they knew the doctor did nothing wrong. There was this institution, the hospital, that everybody assumes has money, and this child in 7 or 6 years would need a particular surgical procedure in order to live, and that procedure was going to cost $650,000. They gave $650,000 because they wanted the child to be able to have that procedure.
There is a word I'm interested in your reaction to, and I think people should be familiar with that, potentially, that may be plaintiffs, and that's the word deviation. Why don't you explain what deviation means within the medical malpractice field?
So there are standards of care for any doctor that must be followed. The standards of care are established by the medical profession. If a patient comes in with these 3 symptoms, you should consider A, B, and C. And if you don't, you could have been careless by jumping to a conclusion that is not warranted by what most of the medical profession agrees to. B, should have been done. However, how can the art of medicine progress if you always are constrained by the same standards of care? We don't put blood-sucking worms on people now to draw blood, do we? That was the standard of care hundreds of years ago for certain situations, but it certainly is not today. So the jurors have to be educated that there are evolutions in the standards of care, and maybe this case is one of them, with a brilliant physician who tested out a procedure, found it to be very useful in a certain circumstance, and used it in this case. Plaintiff's argument could be, well, that was experimental and should not have been done. And that's certainly a factual determination to be determined by the jury.
I'm going to give you three kinds of medical malpractice categories, and I'm interested in your reaction and how you would approach and dissect them. Misdiagnosis.
Misdiagnosis happens for sure. You can be going to a doctor for years and years and years, and the doctor never figures out that you have a molecule, a cell of cancer, which is slowly growing over time, not causing any problems, but without a doubt it was there. It didn't just appear the day he diagnosed it. So some people would say that's a failure to timely diagnose a cancer. Now, there may be veracity to that. Maybe the doctor should have done a particular test, taken a particular x-ray, done particular blood work in accord with the standards of care in treating the patient over the years. But that's to be determined by the jurors. The mere fact that something isn't immediately diagnosed is not indicative of anything. How could it be? You get back to common sense. Cancer starts with a cell, right? Who's going to diagnose that cell and the day it turns cancerous? At this stage in our medicine, we can't do that, and we don't do that. That is not the standard of care, but the jury has to be educated that we're not saying this thing just appeared on the last day the doctor saw the patient that made the diagnosis. Of course it was there before, but there were no clinical symptoms, there were no weight loss, no wasting, no pain, no whatever the case may be. So we had one of those failure to diagnose cancer cases. Turned out that the doctor diagnosed a benign situation. When they took the pathology out, it turned out it was cancerous. And the summation was, if it looks like a duck and quacks like a duck and waddles like a duck, the doctor was entitled to call it a duck and not make the correct diagnosis. The jurors went in with that, found it to be reasonable, and came back with a verdict in favor of the doctor, even though there was an incorrect, shall we say, in retrospect, diagnosis.
The second general classification, which is in line with the first one we touched on, and that is not so much a misdiagnosis as a failure to diagnose. How do you deal with those?
It's sort of the same methodology. First, we have to get all the patient's medical records going back years and years and years to see what was really going on, as opposed to what the plaintiff or his or her spouse, if the plaintiff is deceased, now says was going on. Is supported by the records. The plaintiff comes in and says, I had pain in my elbow for 3 years before this doctor finally diagnosed the problem in my elbow. Well, if the plaintiff was going to an internist and never complained of pain in the elbow, was seeing an orthopedist for some situation, never complained of pain in the elbow, that would be fodder for cross-examination. You didn't, whether you had the complaint or not. Be very careful. We're not saying anybody's a liar. It's a wrong thing to do. Let the jurors draw their own conclusion. The cross-examination is, you did not complain to Dr. A of pain in your elbow, did you? No. You did not complain to Dr. B of pain in your elbow, did you? No. And then you leave it for the jurors to determine what to make of that information. And they do the right thing.
The third category is surgical procedures.
Plaintiffs rarely win on surgical procedures. If the physician, as all physicians have to be licensed and stay licensed by their hospitals, stay credentialed by their hospitals, if the physician is competent, the selection of procedure A over procedure B is difficult to prove to be malpractice, whichever decision is elected by the professional. Because your doctor is going to come in and say, well, I would have done A, and your doctor, Dugan, did B. my doctor's going to come in and say B is perfectly appropriate. And what you say you would have done is totally irrelevant. What's the standard of care? What do other doctors do who are equally learned and experienced? That's the defense.
There's a very interesting phrase called informed consent and the disclosure of the risks involved. Why don't you talk about that from your defense perspective?
Every patient is entitled to know what are the risks of the procedure being contemplated by the treating doctor. What are the benefits to be obtained by undergoing that procedure? What are the percentages of getting better or worse undergoing that procedure? We're all entitled to that information. Hospitals have processes in place where the surgeon cannot do a procedure without having the written, signed, informed consent in the file. It's a very difficult case for a plaintiff to prove. In I don't know how many malpractice cases I tried to verdict, I lost one on informed consent. It's pleaded with every single summons and complaint, but rarely prevailed on.
I want to talk about infants and birth injuries to them. That's a very significant category of cases.
Very, very emotional. The mother does nothing wrong. 9 months during her pregnancy, I hope not 9 years, follows the doctor's advice, goes into the hospital timely, gives birth, and the child is afflicted with neurologic disorders, whether it's seizures, mental retardation, whatever it may be. It's not the mom's fault. It sure as heck isn't the baby's fault. The finger gets pointed to the obstetrician. Why? These cases are enormously expensive for the mother and father. The child's going to need care from birth right up through a natural death, which is extraordinarily expensive and, quite frankly, breaks the bank. So the state of New York started this fund, the MIF fund, to pay for economic loss sustained by the parents when this happens. That leaves the plaintiff's attorney with pain and suffering of the baby and trying to get emotional pain and suffering by the mom and dad, which through today is not yet permitted by the state of New York. But still, how do you value a baby's loss of brain power? How many millions of dollars are we talking about over the life of the baby? So the cases are extremely expensive to prosecute, to defend, and if lost, payments. So they get special attention when they come in. We look, in addition to what I already spoke about, what we look for, who represents this injured child. John Deere, Wolf and Furman, we have a problem because we know competent plaintiffs' lawyers have already vetted the case with their experts. They already showed the medical records to an obstetrical expert. They've already shown the medical records to a pediatric neurology expert. They've already shown the records to an economist to figure out costs over lifetime. Otherwise, they wouldn't bring the suit, because if they lose on a suit that is specious, they've invested over $100,000 in that case. So you look at the plaintiff's lawyer. Then it's digging into the records, speaking with your client, speaking with our experts in obstetrics, pediatric neurology, whatever subspecialty is called for, to find out, do we have a medical issue here? Or is this like 30 to 70% of these cases of unknown origin, where you can't legitimately point to malpractice on the part of a doctor or a hospital or a nurse that's causing that injury? We tried vaccine cases where plaintiffs said vaccines cause those damages. We haven't lost any of those because the science isn't there. And we live now, as everyone knows, in a world where many of us don't believe the science. We can't have those people on our jury. We can't. You have to believe in truth. You have to believe in science. You have to go with the best evidence and make a reasoned judgment. And if the reasoned judgment is appropriate, one way or the other, no matter who it helps or who it hurts, that's what's going to happen at the end of the case.
There's something that we're all familiar with known as the statute of limitations. And I'm interested in, from a defense perspective, how do you evaluate and look at that statute of limitations?
So the statute of limitations is a number of years beyond which you can't bring a lawsuit. So for the parent's own cause of action, that might be in a malpractice suit 2.5 years from the birth in a baby case that we're talking about. And you would say, well, what damages have the parents sustained? Well, somebody's responsible for the medical bills, to educate the child, economic loss. For the child's claim, if it could have been discovered, the legislature has determined 10 years is an appropriate time for an action to be brought on behalf of an injured child in New York State.
I want to mention the term notice of claim. Can you talk about that from a defense perspective?
Municipal defendants, not just city hospitals, are protected by what they call a 90-day notice of claim in New York State, which means that within 90 days of the event complained of, if it was discoverable, they have to let the municipality know that, hey, we have a problem here, we're thinking of bringing this lawsuit. Why? It gives the municipality time to investigate to see, do they really have a claim? And if they do, instead of waiting 3 years and settling just before we try the case, maybe we should settle it now. That's the theory behind the notice of claim statute. So it bars many lawsuits because I don't know how widely it's known that if you have an issue, you better see your lawyer pronto.
You know, if you have a family member who dies from a medical malpractice case, can the estate bring a suit?
Sure. The estate would be whoever's appointed by the court to represent the deceased patient. So it might be a spouse, it might be a child, it might be an aunt or an uncle who can bring that claim on behalf of the deceased. And then you get into interesting issues as to what are the damages that a jury is allowed to award in such a case. The person's dead. Obviously, there's no pain and suffering from that date forward, and proving it before the demise is a plaintiff's attorney's job.
As we conclude, I'm interested in any topics that you feel we may not have touched on that is worth explaining from a malpractice perspective on the defense side.
Just one thing, and it's not a plug, but it's a fact people should consider. Don't go to your normal lawyer with these cases, and don't necessarily go to whoever's on the TV or the radio. Go to someone who's actually done them, because they are complicated, and if you make a wrong step, you will be dismissed on technical grounds. So it behooves you to look in your lawyers. Wolf and Furman, I've had many cases with them. I've had cases with the Deary law firm. They know their stuff. You're going to be fine. Just going to the lawyer who did your will, probably not the best idea.
You know, I mentioned at the outset your remarkable 40 plus years in the defense area. of malpractice. And let me say this, Sean, it came through very clearly today. Thanks very much.
Oh, my pleasure. Thank you for letting me be here.